that within days of the September 11th, 2001 terrorist assault on the World Trade Center, defendant and several alleged accomplices on 42nd Street in the vicinity of Times Square shouted at a gathering crowd of approximately 50 people in praise of the terrorist attack and the resulting deaths of police officers, firefighters, and civilians, vehemently expressed their shared disappointment that the carnage had not been greater, and accosted people in the crowd, yelling in the onlookers' faces, "We've got something for your asses." It is further alleged that arguments ensued between defendants and some of the crowd, and that defendant and his alleged accomplices refused to disperse after police officers asked them to do so. Defendant argues that the accusatory instrument, which charges him with two co-defendants with inciting to riot and disorderly conduct, is not facially sufficient and must be dismissed. Specifically, defendant argues that his actions, rather than criminal, were an exercise of his right to free speech under the First Amendment of the United States Constitution. To be sufficient on its face, an accusatory instrument must contain factual allegations of an evidentiary character demonstrating reasonable cause to believe that defendant committed the offenses charged. See Criminal Procedure Law, Section 100.15. These facts must be supported by non-hearsay allegations, which, if true, establish every element of the offense. See Criminal Procedure Law 100. Conclusory allegations are insufficient. See People v. Dumas, 68 New York 2nd, 729. And where the factual portion fails to establish every element of the offense charged, a motion to dismiss for facial insufficiency must be granted. After reviewing the complaint and after consideration of the defendant's motion to dismiss and the people's opposition thereto, the court concludes that the accusatory instrument is facially sufficient. Therefore, and for the following reasons, defendant's motion is denied. Penal Law, Section 240.08, provides that a person is guilty of inciting to riot when he urges 10 or more persons to engage in tumultuous and violent conduct of a kind likely to create public alarm. Although Penal Law Section 240.08 does not expressly provide for the elements of intent, courts have recognized that in order to pass constitutional muster, the incitement statute necessarily includes the elements of intent and clear and present danger before one's freedom of speech may be abridged under the Fifth Amendment. Thus, the people must prove not only the defendant's conduct created a clear and present danger of riotous behavior, but also by such conduct he in fact intended to riot and to have a riot ensue. The complaint contains the following narrative of defendant's alleged criminal conduct. Deponent, Police Officer Charles Carlson, states that he observed each defendant at 234 West 42nd Street in the county and state of New York, yelling and stating in substance, "It's good that the World Trade Center was bombed. More cops and firemen should have died, more bombs should have dropped, and more people should have been killed. We've got something for your asses." Capital case in original. Deponent states that a total of 5 defendants were yelling the above statements to a crowd of approximately 50 people. Deponent states that said people gathered around defendants and some of said people yelled back at defendants. Deponent states that defendants did approach people in the crowd and yell in their faces.